Hello and welcome. I am Professor Rashmi Raman and you are now in Module 17, The Crime of Aggression in International Criminal Law. In this module, I hope that you will be able to learn, firstly, the unique position and the importance of the crime of aggression in the Rome Statute of the International Criminal Court, including its drafting history. And secondly, I hope that you will understand the elements and the application of this crime of aggression. Let us begin with understanding the unique position of the crime of aggression within the Rome Statute of the International Criminal Court. You will have noticed that aggression is considered widely to be one of the most important crimes within the special jurisdiction of the International Criminal Court under Article 5 of the Rome Statute, which lists the crimes. However, in contrast to the other three crimes, that is genocide, crimes against humanity and war crimes that we have done so far, the court has remained unable to exercise its jurisdiction over the crime of aggression since the statute did not define this crime or set out jurisdictional conditions to be met in order to be able to prosecute this crime. It was only after 2 weeks of intense debate and years of preparatory work on the 11th of June 2010 that the review conference of the Rome Statute of the ICC held in Kampala, Uganda between 31st May and 11th June 2010 adopted by consensus an amendment to the Rome Statute of the ICC which included a definition of the crime of aggression and a regime establishing how the court would exercise its jurisdiction over this crime. Now, Article 8 defines the individual crime of aggression as the planning, preparation, initiation, or execution by a person in a position of leadership of an act of aggression. It is important to note the requirement that the act of aggression must constitute a violation of the Charter of the United Nations. This is a unique requirement when compared with other crimes. For the purpose of the Rome Statute, the crime of aggression means the planning, preparation, initiation, or execution by a person in a position effectively in authority to exercise control or to direct the political or military action of a state, of an act of aggression, which by its character, gravity, and scale constitutes a manifest violation of the Charter of the United Nations 1945. To understand what this means, one must understand that the act of aggression for the Rome Statute means the use of armed force by a state against the sovereignty, the territorial integrity, or the political independence of another state. Behavior forbidden in the Charter or in any manner inconsistent with the Charter of the United Nations. Any of these acts, regardless of a declaration of war, shall, in accordance with the UN General Assembly Resolution 3314 of 14th December 1974, qualify as an act of aggression. 1. The invasion or attack by armed forces of a state, of the territory of another state, or any military occupation, however temporary, resulting from such invasion or attack, or any annexation by the use of force of the territory of another state or part thereof. 2. Bombardment by the armed forces of one state against the territory of another state, or the use of any weapons by a state against the territory of another state. 3. The blockade of ports or coasts or airports of a state by the armed forces of another state. 4. An attack by the armed forces of one state on land, sea, or air forces, or marine and air fleets of another state. 5. The use of armed forces of one state which are within the territory of another state with the agreement of the receiving state in contravention of conditions provided for in the agreement or any extension of their presence in such territory beyond the termination of the agreement. 6. The action of one state in allowing its territory, which it has placed at the disposal of another state, to be used by that other state for perpetrating an act of aggression against a third state or the state which has consented to be used. 7. The sending by or on behalf of a state of armed bands, troops, irregulars or mercenaries which carry out acts of armed force against another state of such gravity as to amount to the acts that I have read out above, or its substantial involvement therein. Aggression also means the use of armed force by one state against another state, unless it is a case of self-defense or authorized use of force by the UN Security Council. The definition of the act of aggression, as well as the actions qualifying as acts of aggression contained in the amendments, for example, invasion by armed forces, bombardment and blockade, are influenced by the United Nations General Assembly Resolution 3314 of December 1974. The text of Articles 15.2 and 15.3 of the Rome Statute set out the conditions precedent for the court's exercise of jurisdiction over the crime of aggression. Contrary to other provisions of the statute that set out the offences, these articles establish a unique jurisdictional regime mentioning clearly when the prosecutor of the ICC may initiate an investigation into the offence of aggression. Once an incident is referred to the prosecutor by the United Nations Security Council, Article 15.3 of the Rome Statute provides that the court may now apply its jurisdiction over the case, meaning that the prosecutor may proceed with an investigation into the incident so reported by the Security Council. However, a different process than the Article 15 is followed in cases under Article 15.2. The prosecutor can only proceed with an own motion known as proprio motu investigation, or an investigation based on a state referral of a situation into the crime of aggression only in exceptional cases, once it has made quite sure that the Security Council has come to a conclusion that the act of aggression under Article 39 of the Charter of the United Nations has been committed and has waited for a period of 6 months to see if the situation will abate. Where that situation concerns an act of aggression committed between states parties to the Charter, and only after the pre-trial division of the ICC has specifically authorized the initiation of the investigation pursuant to referral by the prosecutor. Article 15.2 also explains that states parties have the option to opt out of the court's jurisdiction under this article by filing a declaration of non-acceptance of jurisdiction with the Registrar of the International Criminal Court. Such a declaration can be made at any time, including before the amendments enter into force, and shall be reviewed by the state party within 3 years from the date of making the declaration. Any determination of the commission of an act of aggression by any organ not being the court will have no adverse effect or beneficial impact on the court's independent determination of whether a situation of aggression exists as provided by Articles 15.2 and 15.3. States that are not parties to the statute are expressly excluded from the court's jurisdiction for a crime of aggression under this article when it is committed by the citizens of that state or on its territory. The amendments were adopted by consensus in accordance with Article 5(2) of the Rome Statute and would have entered into force under Article 121 Clause 5. However, the provisions of both Article 15 Clause 2 and Article 15 Clause 3 provide that the court will not be able to exercise its jurisdiction over the crime of aggression until certain conditions precedent have been met, which is that at least 30 states parties to the convention have ratified or accepted the amendments, and a decision is taken by 2/3 of states parties to activate the jurisdiction at any time after the 1st of January 2017, that is this year. Under this definition, the crime of aggression, the only persons who can be responsible for this offense are state leaders and state officials most responsible and with enough authority to engage the forces into aggressive action. State officials most responsible and with enough authority to engage the forces into aggressive action. Thus, the definition actually rests on the idea that the Nuremberg Tribunal had started, that planning, preparation, initiation, or execution of aggression contains within itself the accumulated evil of the whole, and that the objective behind the decision to include the crime of aggression within the jurisdiction of the International Criminal Court is to prevent the suffering caused by armed conflict by deterring state actors from using aggressive force. Let us now consider the history of crimes of aggression in order for you to more fully appreciate why this has such a unique place in the Rome Statute. The Peace Treaty of Versailles of 1919 condemned aggressive war as a supreme offense against international morality and the sanction of treaties. Thus, the concept of aggression is not new. It was only in 1945 that the Charter of the United Nations, having entered into force, established a system of collective security. The Charter of the United Nations has, of course, Article 2, Clause 4, which says that the threat or use of force against the territorial integrity or political interference of any state in any manner inconsistent with the purpose of the United Nations is a violation of the Charter. After the end of the Second World War, the London Council adopted the London Charter or the London Agreement, which is responsible for the creation, of course, of the Nuremberg Tribunal that we spoke about in one of the earliest modules that we discussed. The Nuremberg Tribunal criminalized the waging of a war of aggression as a crime against the peace. It referred to the crime of aggression, a previously unrecognized standalone crime, as the supreme international crime, differing only from war crimes in that it contains within itself, as the tribunal put it, the whole accumulated evil. Thus, the London Council very clearly recognized aggression as the core beginning of international crime. While the United Nations General Assembly later recognized the Nuremberg Principles as international law, and the International Law Commission went on to codify the important rules and principles established by both the Nuremberg and Tokyo tribunals respectively in what they called Nuremberg Principles. The ILC did not define the term aggression. In December 1974, the United Nations General Assembly adopted Resolution 3314, where aggression was defined as a guideline to the work of the Security Council. This definition was based on the concept already mentioned in Article 2.4 of the Charter and enumerated specific examples of acts of aggression. The July 1988 conference that led to the adoption of the Rome Statute of the International Criminal Court spent a great deal of time heavily debating whether or not to include the crime of aggression and to give it a definition. Finally, the crime of aggression was included in the list of 5 crimes that came under the jurisdiction of the International Criminal Court, but its definition could not be agreed upon at that point and the debate was rendered moot. It was only in 2010, almost 100 years after Versailles, that the Kampala Review Conference used the definition of the crime of aggression in the Rome Statute and adopted it, subject to the condition that the Assembly of States parties would take a further one-time decision to activate the jurisdiction of the court not before 2017. A little history about the Nuremberg trials. As you know, the Nuremberg trials were trials in military tribunals held by the Allied forces after World War II, known for the prosecution of distinguished members of the leadership of the Third Reich. With respect to the crime of aggression, they may, to an extent, be perceived to be the beginning of the definition of the crime. In Nuremberg, aggression was synonymous with the term crime against peace. Article 6 of the Charter of the IMT includes the same elements as the current definition under the Rome Statute, which is planning, preparation, initiation, or waging of a war of aggression, or a war in violation of international treaties, agreements, or assurances. It further includes participation in a common plan or conspiracy for the accomplishment of any of the acts mentioned in Clause 1. Sir Ian Brownlee, a noted scholar of international law, studied and argued that the provisions of crime against peace were the result of a compromise to make a charge of launching aggressive war alternative or additional to the charge of initiating war in violation of treaties. Now, the Charter of the International Military Tribunal for the Far East, or the Tokyo Tribunal, also defined crimes against peace on the basis of the same manner in which the Nuremberg Tribunal adopted it. The only difference is that they added a phrase, declared or undeclared, with respect to the war of aggression. This became very important in the context of the struggle in the Far East. In Article 6 of that charter, 2 aspects are highlighted. One, that the underlying principle of ratione materiae involved in the notion of participation used by the definition evades the issue of defining aggression in using the word war of aggression instead, leaving it quite vague and rather ambiguous. The second important aspect that we have gained out of comparing the origin of aggression from Nuremberg was that the international criminal concept of crime against peace was always recognized as the supreme international crime. The definition might have been vague or evasive, but the Nuremberg trial itself played a very important role in the creation and development of future principles of international criminal law. The unanimous approval of the resolution by the General Assembly of the United Nations led to an eventual recognition of the crime of aggression and to it being established as one of the 4 core international crimes under the Rome Statute. Further, the dismissal of the nullum crimen sine lege rule, which the Nuremberg Charter was the first to recognize crime against peace as a supreme crime, and also the first to propagate individual responsibility for violation of this crime instead of mere state responsibility. Let us look at how these 2 skeins of responsibility developed independent of each other: state responsibility and individual criminal responsibility. As we have discussed previously, Article 8, Clause 2 of the Rome Statute of the International Criminal Court defines the crime of aggression with respect to the act performed by the person of a state with the most authority to engage in such an act. Scholarship believes that 2 qualifiers are seen to have been used here. One, that of the act being performed by an individual, and that of the individual belonging to or being a national of a state. This difference in terminology is more noticeable when compared with the language used by Article 16 of the Draft Code of Offences Against Peace and Security of Mankind, adopted by the International Law Commission in lieu of adopting a clear definition of aggression. In this draft code, aggression is said to have been committed by a state. This has led to some scholars propagating the idea of two concepts being linked to the act of aggression and the crime of aggression, one of state responsibility and one of individual responsibility. The debate is that in order to prosecute an individual, proving the existence of aggression in the given state is important. There has to be an inevitable link between the international responsibility of a state for aggression and the individual criminal responsibility that comes out of that for crimes of aggression. Thus, it is only after a state has been declared as an aggressor that an individual may be tried on the basis of this legal nexus for the purpose of individual criminal responsibility under the Rome Statute. So you see, the crime of aggression and the act of aggression are two separate incidents, and they seem to depend on each other. For an act of aggression, it is a state responsibility, and for the crime, the Rome Statute comes in. First, the Rome Statute defines the crime of aggression in paragraph 1 of Article 8 and then qualifies it with a definition of what constitute acts of aggression in paragraph 2. As we have discussed in the preceding portion of this module, the crime of aggression refers to the steps, that is planning, preparation, initiation, execution of the act of aggression. So in order to understand the crime of aggression, it is important to understand and define an act of aggression. Para 2 of Article 8, Clause 2 of the Rome Statute defines the act of aggression as the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state or any other manner inconsistent with the Charter of the United Nations. Essentially, a 2-4 violation of the Charter. This second qualifying paragraph of Article 2 also tells us that in accordance with the resolution that we have spoken about before, that is the UNGA Resolution 3314, certain acts would qualify as acts of aggression irrespective of the formal declaration of war. The conditions that imply state aggression, whereas the crime of aggression implies individual or great authority of an individual within a state. Now, this hierarchy or this differentiation has been used as a means of making a clear-cut distinction between the act of aggression and the crime of aggression. And certain proposed amendments have been made to further clarify the difference. It is also argued that while such an amendment might be welcomed, Article 5.1 states that the jurisdiction of the court shall be limited to only the most serious crimes of concern to the international community as a whole. Now, the real question that you should be asking is whether aggression falls within this in the same way as it fell in 1919. Let us now turn and look at the elements of the crime of aggression. The crime of aggression has two elements. One, an objective element, actus reus, and two, the subjective element, mens rea. International law appears to consider the activities of planning, organizing, preparing, or executing in the use of armed forces by a state or non-state actor or any other organized entity against the territorial integrity, sovereignty, and political independence of another state, an act of aggression. Thus, as an objective element, the crime of aggression includes the following features. One, that it be against the territorial integrity of a state, and that it never be perpetrated by independent individuals acting severally. Instead, it always results from some sort of collective action of a plurality of persons. attributable to important political positions within a state. It is also attributable to political and military leaders and other senior state officials, that is, those who are the creators, initiators, or organizers of such a crime. The second element in such a crime is the subjective element. This deals with the concept of intent. We have already spoken about this in a preceding module. This crime requires a modicum of knowledge. Whether the person or group of persons had intended to participate or had the knowledge of participating. This also raises another dimension of responsibility. If a person, a leader or high-ranking officer or senior state official or leading private personnel, including mercenaries, possesses the knowledge of other leaders, plans and willingly with this intention pursues the plan, knowing of its criminal objective and the end result. Now, this is a matter on which international law is very clear and direct. Only if the end result is known to the perpetrators can criminal intention be attributed. Let us now turn to the jurisdiction of the crime of aggression and the conflict that arises between the Security Council and the International Criminal Court. The matter of jurisdiction in the crime of aggression is one of extreme controversy. This controversy relates to the difficult relationship between the Security Council of the United Nations and the International Criminal Court. This relation is regulated by Article 5, Paragraph 2, Article 13, Clause B, and Article 16 of the Rome Statute. Article 5, Paragraph 2 of the Rome Statute states that the jurisdiction of the court shall be limited to only the most serious crimes of concern to the international community as a whole. It further limits the jurisdiction of the court to enumerated crimes of genocide, war crimes, crimes against humanity, and the crime of aggression. In this article, the statement that the jurisdiction of the court with respect to the crime of aggression should be consistent with the relevant provisions of the Charter of the United Nations implies that the decisions of the International Criminal Court and those of the Security Council with respect to whether a state has committed aggression or not are in consonance with each other. This is important to determine individual responsibility for the crime of aggression. Article 13b of the Rome Statute says that the International Criminal Court may exercise its jurisdiction to a crime referred to in Article 5, Clause B in a situation in which one or more of such crime appear to have been committed, and this is referred to the prosecutor by the Security Council acting under its Chapter 7 powers. Article 16 deals with the deferral of investigation or prosecution and says that no investigation may be commenced or proceeded with under the Rome Statute for a period of 12 months after the Security Council in a resolution adopted under Chapter 7 of the Charter of the United Nations has requested the court to that effect. That request may be renewed by the Council under the same conditions. In reality, however, this leads to a tussle between the Security Council and the International Criminal Court. In conclusion, a study of the articles that we have just discussed show that the Charter of the United Nations explicitly trusts the Security Council with the task of determining the existence of a crime of aggression. This makes the decisions by the ICC and the Security Council very difficult. The ability of the ICC to exercise its jurisdiction depends on the Security Council's ability to determine whether aggression has been committed by that state or not. Also, should the ICC find that there is no legal connection between the aggression and the crimes committed by the individual accused under that state, there develops a point of contention between the ICC and the Security Council. This may also lead to further problems of complicated cooperation between important bodies of international law, And also the problem of morality, where the question of not being able to serve justice with no bias is questioned. It could lead to polarization, politicization, both of which create a legitimate overlap between the political and judicial functions, where the lines of differentiation are blurred and impartiality is as a result compromised. Thank you.